Welcome to Frank Bruno's Law. Frank Bruno's Law. Frank Bruno Law. Frank Bruno Law. Welcome. I am a probate and elder law attorney in New York. Today's topic: what is the dead man's statute? About half of the states in the United States have a dead man's statute or dead man's rule, and you face that sometimes in estate proceedings, although not exclusively in estate proceedings. Before I get to that, if you would like to speak with me, please go to frankbrunolaw.com and schedule an appointment. So when there's a will, or even without a will, and there's an intestate proceeding with a will or without a will, and even in situations where it may seem cut and dry, someone else can come in and say, or try to say, I had a conversation with the decedent and I'm entitled to something. The dead man statute is designed to prevent conversations with this interested person and the decedent, the deceased person. It's designed to prevent those conversations from being presented to court. And the reason for that is because it's difficult to challenge these statements. And then we have a she said, he said, she said, he said type of situation, right? Battle of the conversations. And difficult because one person in that conversation is deceased. Now, if there was such a conversation, any third-party witness to that conversation may be subpoenaed. There are exceptions to the dead man's rule. And for example, say you're a plaintiff in a motor vehicle accident, and the driver of the motor vehicle, the plaintiff in that situation can in fact testify. This comes up in litigation, and oftentimes the surrogates court faces arguments and has to rule on whether or not the dead man's rule applies. It's a little bit complicated. There's no federal rule. It goes state by state, and you have to follow the specifics of the facts. Many things in the law are fact specific. If you have such a situation, please reach out to me, frankbrunolaw.com.